Good morning, everyone. Thank you so much for joining us this morning. This is number 5 webinar in our series of Secrets of Successful Retirement. Today's topic is legal documents that everyone needs, and today we have a special guest, one of our partners, Andrew Friedman. He is an elder law attorney that is in our office. So just to tell you a little bit about some housekeeping, there is a talk button at the top of your screen. Anytime during the session, if a question comes to you, you can go ahead and click on that and type it in, and at the end, we'll be covering all the questions. So at Senior Resource Center, we help in 4 different ways. First is we do comprehensive retirement planning. We help people look out into the future. We do 30-year retirement plans. We want to make sure that people don't outlive their money. Next is we do tax planning to help people pay less tax. We also do long-term care planning that includes Medicaid planning and VA planning. And we also do estate planning and things like helping people avoid probate or make sure that they have the right legal documents, which is what we're covering today. So without further ado, I'm going to introduce Bill Witt, my partner. He's going to go over a couple things, and then Andy.
Thank you, Tara. Let me add my welcome to everybody, to Tara's. Welcome everybody to today's webinar. This is the first of actually 3 legal webinars that are part of our 13 webinar series. This one deals with legal documents. 2 of the future ones, one will focus significantly on probate. We'll explain what it is and how to avoid it. And then there's a third legal webinar that's going to focus on trusts and explain those, because those are something that a lot of people have questions on. I always begin every webinar with a disclaimer, and this one is pretty similar to the past ones. Everyone's situation is unique. Your situations determines the specific legal documents you may need. And Tara and I are not attorneys, so we ask you to refer all questions to a licensed attorney like Andy Friedman. By way of introduction for Andy, Andy and I have worked together for 18 or 19 years. When I first started doing this, we were officed somewhere else, and we found Andy, and he was helping our clients with legal documents. And sometimes people ask me, well, why do you office where you do? And my answer is always the same, because that's where Andy is. It's easier to walk down the hall and introduce someone than to have drive across town. Andy's helped our clients with a variety of things: estate planning, qualifying for Medicaid benefits, qualifying for VA benefits, both those to help pay for long-term care. So he's a trusted partner, and I think the strongest thing I can say about this is it's not what Tara and I know in our practice, but it's the trusted partners we know and what they know. It's not what we know, but who we know. And Andy's a great example of this. He's helped many, many of our clients. So with that, let me turn the webinar over to Andy.
Hello, Bill and Tara, and all our assembled audience. I just want to say thank you for inviting me to talk with you today. I'm going to be doing actually something I really enjoy, which is listening to myself talk. So at a certain point, Bill and Tara will take the mic away from me. But between now and then, we're going to be talking about estate planning. As Bill mentioned, I am an estate planning attorney with a focus on elder law and asset protection, as well as probate. And I want to start out by kind of giving a context for estate planning that may help the rest of what we're talking about make more sense, or at least fall into place. The definition I've used for decades for estate planning is to provide for yourself and your loved ones, protect your wishes and direct how your property is used while you are alive and after you die, and minimize the court costs, legal fees, and taxes. Now, within that context, there's some tools you can use, and not using the right ones can frustrate these goals and cause you unnecessary expenses and, quite frankly, stress you out. I'm going to launch right into it and hopefully control the slides correctly. Within estate planning, I guess there's one more bit of context I need to mention, and that is, what is an estate? That has a variety of connotations, but For legal planning purposes, an estate is you, your loved ones, and anything that is yours. So your money, land, investments, assets, anything you have an interest in, whether it's in your name or not, that all taken together is rolled up into your estate. So estate planning is taking control of that. Um, um, as an overview, these legal documents that you'll use to plan your estate fall into two broad categories. One is what happens during your lifetime. I generally refer to these as your ancillary documents because they aren't the big ticket items like the will and the trust, but I find them far more interesting because, as I mentioned, they're the ones that apply while you're still alive. What happens after you die is extremely important, but frankly, it's not that interesting. It's just dividing up what you have at that point. Um, Within the context of ancillary documents, I think the primary guide is you want to make sure you have named the right people to help you out, both in financial matters and in medical and healthcare matters, and that you've given them enough instructions to know what to do, and that you've given them sufficient authority that isn't suddenly stopped or taken away from them. See? All right. Now, planning is what we're going to be talking about, but there's an alternative, and this is what happens if you don't plan. Well, even in that situation, the state of Texas has created a default plan for you. Again, the two categories of time you're looking at are during your lifetime and then after your death. During your life, while you have full capacity, you don't really need planning documents. You're just making decisions for yourself and your property and your loved ones. But if something happens to you, and by this I don't mean a physical ailment, I'm talking about mental. We all face the concern of forgetting things at times. That increases as you get older. And the concern is you may reach a stage, and it's not a bright line to termination, it's a gradual process where you really lose capacity to take care of yourself and your property and your family appropriately. The problem with not having a plan is there's no one who can act for you if you haven't given them the authority in advance. So the default plan is what happens if you don't make a plan? And just by way of sort of, I guess, cheering you up, if that's the case, most people never get around to this. Estate planning is always something people give lip service to and say, yeah, I'm going to get to that. That's very important. And they never quite do it. So the state of Texas has actually stepped in and said, okay, let's assume you won't make a plan. And let's assume you become incapacitated and something needs to be done for your health, for your medical reasons, to take care of your property, and you haven't given anyone the authority to act. Well, in that case, the default is someone, usually a family member, a spouse, or an adult child, has to sue you. That's right. The default is a lawsuit. They sue you in the probate court and try to prove that you're incapacitated. If they're successful, they make you a ward of the state. In other words, the judge takes away your legal adult rights and responsibilities and gives them to someone else who's called your guardian. You become a ward of the state and a guardian takes over. And there are two kinds of guardian. One is, I think, fairly necessary, and that's a guardian of the person. That's sort of like a new parent. That person decides where you live, who has access to you, where you can go, what kind of activities you can engage in. The second kind is somewhat more insidious, although it seems reasonable. If you can't take care of yourself and you may be a danger to yourself or others, you probably can't balance your checkbook, can you? So the judge will consider that and say, well, we need a guardian for your estate as well. Understand if the judge goes down that path, it's the death knell for your estate plan. At that point, the court takes control of everything you own. And since the court and the state of Texas are really abstractions, they have to appoint a person called a guardian of your estate who takes care of your property from that point on. they have to continue coming back into the court on a regular basis, either quarterly or monthly for the rest of your life, with all the attendant attorney's fees and court costs for each of those hearings. And that's just for accounting to say what's happened since the last time you were there. Secondly, they have to have special hearings if they want to take care of your property to like sell something. Perhaps you have an investment that's not doing too well and they need to sell it. Well, no one has the authority except the guardian of your estate, who has to act under court permission. So another hearing. Again, attorney's fees and court costs. And that's not all. If you're in that situation and you have these hearings, there are people who have a statutory right to be involved. These are people with a vested interest in your estate. Those are your creditors, the people you owe money to. They have to make sure that the assets are not being mismanaged. So they're there at the hearings also with their attorneys, and you get to pay for them as well. So a guardianship of the estate essentially is an accelerated route to bankruptcy. The second default estate plan is what happens at death. Well, here the legislature, I think, did something fairly reasonable. They decided who is the likely beneficiary to your property, and they created what are called heirs. Heirs are the statutory beneficiaries, and it depends on whether the property that they're dividing is community property, if you're married, or separate property. And there are different heirs for each of those. There's nothing wrong with the setup the legislature decided because it applied to them as well. They had a vested interest in making sure it was done correctly. The problem is it's a cookie cutter, one size fits all. If you want some of your property to go to certain people and they're not your heirs, they're not going to get it. So the default estate plan is exactly that. It's what happens if you don't plan. It's not horrible, but it's not particularly good. Okay. Bill has mentioned that this does happen on a regular basis. In fact, I spoke with someone that he had discussed this with just yesterday. He was in a situation where he and his wife had taken the time to write out handwritten wills. And just so you know, a handwritten will is legally functional if it takes care of the right things. The problem is they wrote those down and then put them somewhere and they can't find them. This gentleman and his wife are second marriages. So they have a blended family. Each of them brought children in of their own. That's a problem. When you're determining heirs, as I mentioned, it depends on whether the character of the property is community or separate. In this case, they have community property, which usually goes to the surviving spouse at the event of death. And what I forgot to mention in this situation is the woman had died. So the gentleman who called me, his wife had died. So he was searching for their handwritten will, or rather hers, and hadn't been able to put his hands on it just yet. And I thought, well, perhaps we could do an heirship, going through intestacy, the default in the event of death. Well, the problem there is the heirs for community property is not the surviving spouse. Surviving spouse gets one half. The other half goes to the children of the one who died. So that would be her children from an earlier relationship and their one common child, but his child or children would be left out. This was not at all what he wanted, and we're hoping we can come up with something, but it really hinges very greatly on whether or not they can find those handwritten wills. All right, the legal documents, which you can make part of your estate plan, in other words, your determination of what should happen during life and after death, are broken down into a number of categories. I'm going to start with what I call the ancillary documents, the ones that happen during life. And those are very broadly your financial power of attorney, your medical power of attorney, your living will. In Texas, it's called a directive to physicians and family or surrogates, a HIPAA authorization, a designation or declaration of guardian, and possibly a trust. After death, there are three other documents. There's your last will and testament, which again takes place after death, a trust, which you may see is in both columns because it deals not only with lifetime but also after death matters, and then beneficiary designations, which you're probably familiar with. If you have a financial account, you can simply say who gets the property at your death. All right, let's start with the first of those. What is a financial power of attorney? As I mentioned, or I should have, the name in Texas is a Texas statutory durable power of attorney, rather a mouthful, but its purpose is exactly the same as you might think of generally a power of attorney. The first is you are going to appoint someone, or maybe several people, to make decisions relating to the things you own. So they're financial and property decisions that need to be taken, and you can't do it, so your agent is allowed to. You have to make a determination when you set this up. Do you want it to be immediately effective, or rather effective triggered by your disability? Now, there's a common thought here. I'm just going to make mention of it, not dwell on it too much. And that is the immediately obvious choice is, well, I don't need anyone to act for me now. I'm fine. I want to have this triggered by disability. There's two thoughts I want you to take on this. The first is if you don't trust someone to be your agent while you're in full capacity and can ride herd over them, why would you trust them more when you're disabled and unable to do so? Secondly, if you say this document is triggered by my disability, you're relying on third parties like banks or places where you have your investments to accept the authority of your agent. If that authority is triggered by disability, that bank is going to say, prove he's disabled, prove that she has become incapacitated. And there's no way of knowing in advance what kind of proof will be satisfactory, which might mean that the power never actually gets used. Usually, these documents are notarized. The primary purpose for notarizing a financial power of attorney is so that it can be filed in the deed records. If your agent ever needs to take care of land or deeds for you, the power to do so has to be filed already, and county clerks will not accept documents that are not notarized. Now, there's a suggestion on the slide, and I do wholeheartedly stand behind this. I strongly encourage not appointing multiple co-agents. This happens a lot when I have a client who's a parent and he or she comes in and says, well, we trust our children and we're not trying to pick favorites among them. We'd rather have all of them serve together. I will suggest that that's a logistical nightmare. Anyone that your children/agents are trying to deal with may require them all to be there at the same time. So if your one child lives in Alaska and the other here in Texas, and the bank says, we're not going to do anything unless both people agree and we need them both here in front of us, well, then the child in Alaska is going to be facing a lot of travel time to carry out your orders. So we'll go ahead. The next of the major documents, lifetime documents, is your medical power of attorney. This is the Texas term for it. In different states, they're sometimes called durable power of attorney for healthcare, durable medical power of attorney. We have chosen the last, the medical power of attorney. Once again, just as with the statutory durable power of attorney, it's where you appoint someone to make a medical decision on your behalf. So medical, healthcare, any kind. I do suggest that you have here, as well as on the financial power, multiple agents. There's the old triplicate redundancy idea from governmental and military matters. If you name 3 people in a row, there's a good chance someone will be locatable and willing to act in your place. If you name just one, it's better than none, but there could be problems if that person can't be reached or if that person freezes when they're supposed to act. Um, the medical power of attorney takes effect when you can't take a decision on your own. And understand this is triggered by your healthcare provider. So if your physician is with you and says, okay, should we do X, Y, or Z to take care of your healthcare problem, and you're in a coma, well, then you can't answer. That's when your doctor writes down, okay, my patient can't take a medical decision. At that point, the medical power springs into effect, and the first named agent has the authority to act for you. This is something Texas legislature spent a lot of time on. They were very concerned by constituents who feared that this would be uh, a problem where there was a deathbed situation. And I guess the idea was you could be lying in your deathbed thinking, I want to live. And your agent said, oh, just go ahead and pull the plug. Understand that actually cannot happen. The way it's set up, the medical power of attorney is yours. It springs from you in the sense that you share it with people, but they never override you. So if you can make a decision, I'll suggest to you your doctor will always be asking you first. They'll only go to your agent if they can't get any response from you or it's clear that you can't understand or make a decision. Um, the form of this document can be witnessed by two people who are not related to you and don't work at the hospital and don't benefit from your estate, or it can be simply notarized, which is what's generally done these days. Here again, I would suggest you not appoint multiple agents. Legally, it's not clear whether you can have co-agents. I think it's better to approach it from the sense that you're naming people serially to serve in order. Okay, the next document is broadly referred to across the country as a living will. In Texas, it's called the Directive to Physicians and Family or Surrogates, and sometimes also called an advance directive. This is the means where you give instruction and guidance to your medical agent and sometimes to your doctor about what kind of decisions you would like taken regarding your medical or healthcare condition. Um, Oftentimes, these are focused on end of life decisions. The two big ones are what's called a terminal condition, where your treating physician has said, you will die in 6 months, regardless of what we do. Your life expectancy is now a 6 month time period. In that situation, if you're willing and able to make the decision, you'll focus on either keep yourself alive, use whatever kind of medical treatments are necessary to sustain your life, or keep you comfortable, whatever is necessary to minimize your suffering. Now, understand in a terminal condition where you have 6 months or less to live, those are usually quite disparate choices. Um, Cancer, for example, stage 4 cancer, you face the cocktail of surgery, chemotherapy, and radiation, where they cut out the cancer, they burn it, they poison it until there's not enough left of you to live. Alternatively, they can give you morphine, other pain medications, and you can minimize the symptoms. But more than likely, then the cancer will spread and you die quicker. The living will allows you to take that decision in advance. And I can't emphasize how important this is. If you don't do this, someone else has to do it on your behalf. And that is a horrible burden to put on someone else. Your medical agent will have to decide sustain your life or allow you not to suffer as much. So by literally initialing the box, you can take that burden away from them, and your medical agent doesn't have to decide that. There's a second decision related to end of life care, which is called the irreversible condition. And again, these are terms that are set up by statute. I didn't come up with them. The irreversible condition basically is summed up by you have a condition that will kill you if it's not treated, but if you are treated, it won't affect your life expectancy. So this can be anything fairly commonplace, like, say, diabetes, or it could be as horrible as what happened in Florida a number of years ago with a lady named Terry Ann Shivo, who basically went into a coma and was kept alive, or rather, her body was operated by putting nutrition and hydration, water and food, through tubes. Since she was in her 20s when she went into the coma, she would probably still be with us today, but eventually the decision was taken to stop those tubes. That is an irreversible condition. If she were given that food and hydration, she'd still be with us. So her life expectancy wasn't affected. However, she did have something that would kill her. And as soon as the nutrition hydration stopped, She died, I think, exactly as the doctors predicted in 13 and a half days. Here also, it can be a notarized or witnessed document. Again, notarized simply seems to be easier from a tactical standpoint. All right, now we come to one of the big ticket items. What's your will? A last will and testament. Well, this is a document that divides what you have among those people that you choose to receive it at your death. So, really, I think it has two and a half purposes. The first one is to appoint a personal representative to take care of your property, to gather up your assets, pay your creditors, and distribute what remains. Under a will, that personal representative is called an executor. If you don't have a will, the personal administrator is, or personal representative is called an administrator. Again, the function is the same, it's just the terminology. The second duty is to divide your assets. And I said two and a half because really there's two kinds of properties you're concerned with. One is specific gifts where you have heirlooms or small cash bequests or just memorial type gifts where you want to benefit someone by giving them something to remember you by. The second portion is what's left over. That's called the residue or the residuary estate. After those initial heirlooms have been given out, everything else is called the residue. Your executor is given instructions in the will. The first is to what they call marshal your estate, which is to gather up all of your assets and to manage it and administer it during the term of the probate. That includes paying your bills and taxes and all other costs and expenses. And then after resolving all the creditor claims and all the court costs and attorney's fees, then to pass on what remains according to the terms of the will. So understand here, the creditors are rated higher than your beneficiaries. The last thing to remember is this does require probate. Now, again, the probate function we'll talk about next, but probate is required to give effect to the will. Without that, it's just so many pieces of paper. So, what is probate? I'm sorry?
Yeah.
Bill reminded me we are going to have a subsequent presentation where we talk about probate in more depth. But just so you know, the purpose of probate is it is a legal proceeding, so it takes place in court, and its purpose is to transfer title to your property and appoint a personal representative. Once again, either an executor under a will or an administrator if you don't have a will. The court is the enforcement mechanism. The will or the terms of the heirship under intestacy law are enforced by the court or can be enforced in that forum. It is a public forum. This is not something that's done privately, since it involves making sure that title passes at your death to the people who should get it. That has to be a public record. So the forum for probate is also public. And then lastly, there's a reference here to the fact that your will and your heirship only cover probate assets. You may say, well, that kind of makes sense. It's a probate forum. Yes, but a probate asset is something that doesn't have some other contract controlling it. So understand a lot of your property may very well be non-probate. These are things where you have a contract like a pay on death instruction with a bank, or a transfer on death or beneficiary designation with an investment or brokerage, or a life insurance policy or retirement plans. Those all have beneficiaries designated in the contract. And that contract takes it outside of probate, which means your will has no effect over it. The other alternative, as I call it, a big ticket item, is a trust. And I have to be careful here. The last time I had a colleague review this, there are 65 different kinds of trust. What I'm talking about here is a revocable living trust. It's seen as an estate planning tool that covers a lot of the same ground as a will and a power of attorney and an instruction manual. So it's usually a longer document. But just to go back to basics, what is a trust? And understand this will be the subject in more detail of a later presentation. A trust is a legally recognized relationship between three people. Trust maker, who's the one who sets it up and puts property into it. The trustee, who administers all that property, and in the eyes of the law is the legal title holder to the property. And then the beneficiary, and that's the person who benefits from all this. Understand, when I say it's a relationship, that relationship is what is meant by trust. So it's not, despite my use of the pronoun, it's not an it, the same way that a corporation or an LLC or a partnership is. This is a relationship governing benefits and title relating to property, and it's recognized by law. Property that is held in this way, in the name of the trustee, is not subject to probate, and that's both post-death probate and the living probate of guardianship of the estate that we touched on briefly before. It's effective as soon as you sign it. So effectively, it is a contract. Once you sign it, it goes into play. It contains instructions that you come up with that divide or set up who benefits and how property is to be managed, both during the term where you are disabled and then again after your death. Um, it directs how your creditor payments are supposed to be made. It directs how your property is to be distributed at your death. So again, it covers the same ground as a will does. It also covers the same ground as a durable power of attorney. In fact, it has more power than a durable power of attorney. So a trust can be a remarkably useful device, but understand it can be very simple or it can be extremely complex, entirely dependent on how much instructions you want to put in play. So what is the goal of all this? Well, I've got a sampling of what I think of as kind of the key areas in which estate planning is a useful tool to make use of. The first is disability planning. If you become incapacitated, and once again, I'm not really talking about physical ailments, although that can be addressed in it, but if you become mentally incapacitated, forgetful, not thinking clearly, whatever, and you have a plan in place, things go a lot smoother, with a lot less cost and with a lot less chance of you losing all of your property than if you don't have a plan. Secondly, and very importantly, you can prepare and provide for your spouse if you're married, and for your minor children, and quite frankly, for adult children, any beneficiaries. Thirdly, it allows you to balance those beneficiaries you might have in blended family situations. And blended families here, I'm talking about where people have second marriages, either on one or the other spouse's side, where there are children from both sides, and therefore there are potentially conflicting or even competing interests. You can decide how you want your property used. You can decide how you want to address that blended family issue, but it requires you to write down in some form or fashion what your plan is, and that's part of your estate plan. Asset protection is another key aspect here, and this is one of the main focuses of my practice. This is not saying I'm going to keep it from everybody. It's, can I protect it from being what I own, from being taken from me in certain circumstances where I really would like not to have that happen. Asset protection can cover a lot of situations. Um, Two of the big ones that are worth mentioning here are lawsuit protection and, secondly, divorce protection. Catastrophic illness planning is something else to be addressed in your estate planning. If you have um, some horrible healthcare condition that hits you later in life, which has major costs, your planning in advance can determine how you're going to address that. It's got a financial component, how you're going to pay for this, but also how you want it acted upon. Retirement planning. You don't have to be suffering from incapacity. You could retire from working and you still want to make sure, once you're on more static income, that your self, your property, and your family are taken care of appropriately. You can promote your own values. Um, a very simple example is where you have a parent who wants a child to act in a certain way, or perhaps go to a certain college, or go to college at all. Your plans, to the extent they're written down and you have good advice and sufficient authority granted, you can make sure that happens even if you're not there able to do so yourself. You can leave a social legacy. This is the charitable side of the planning, where you wish to benefit charities, worthy causes, organizations, churches that you really want to benefit. Once again, your estate plan allows you to do that. And then last, but certainly not least, to the extent you die owning property, there's going to be a tax situation. Well, you can address that in advance by meeting with financial professionals, deciding what would be the best approach for you, and then writing it down. That is your estate plan.
Andy, you've covered a lot of ground. Now I know why it takes so many years to go through law school and learn about all of the different things that we can run into. And I think, Andy's side of the practice of helping people with legal documents is it parallels what Tara and I do. Planning ahead for retirement is better than reacting to events as they occur. And I think you can do that financially, you can do it legally. Uh, so we've had a long and very fruitful relationship working with Andy. He's helped many of our clients address all of these range of issues and challenges that can come up as we go through retirement and then after we die. So, Andy, I want to thank you for joining us. Tara, do we have any questions from any of our viewers?
Yeah, it looks like we do. If you guys have any questions you want to give us, please, go ahead and get that talk bubble at the top, click down on it, and you can type the question in there. So let's start with our first question. Okay, Andy, can my financial power of attorney, or what do you call it, durable power of attorney, can they make medical decisions for me?
Very good question, Tara. No, in fact, the Texas legislature made it very clear that those two powers are distinct. The agents that you appoint under your financial durable power of attorney can take any decision that you can, that you've authorized them to, relating to your property, but they cannot take a medical or healthcare decision. And the reverse is true. The agents appointed under your medical power of attorney cannot take any financial or property or asset decisions. They only make healthcare decisions.
All right, good answer. All right. Next question is, can my executor help out while I'm alive?
Okay, I get that question quite often, so I appreciate it. Um, Understand, in the timeline of your life, the bright dividing line is your death. Your executor is named in your will and then appointed by the court in the probate proceeding. All those happen after you die. So your executor can't help out while you're alive because your executor hasn't been appointed and cannot be appointed until you die.
Okay. All right. Another question is, this is a good one. Can my will pass on my retirement plans?
That is a good question. The answer is no. A retirement plan is one of those contracts that we talked about, where you have inside the contract the ability to designate a beneficiary for the plan. That's a contract which takes it out of probate, which means your will, and even if you didn't have a will, intestacy and heirship have no effect on it. You have to decide with your retirement plan with the retirement plan administrator.
So does that mean you're saying you just put a beneficiary designation on your 401k, your IRA, your mutual fund?
That's exactly right. A beneficiary has to be designated.
Okay. All right. Next question. What's the cost of assigning a financial power of attorney, medical power of attorney, living will, and will if someone needs these to be completed?
I do get that question a lot also. Um, I don't have just a magic cost button, unfortunately. I wish I did. My practice is, and I think most attorneys I'm aware of who do estate planning are the same way. They need to have a meeting with you first to discuss what you want to do and make sure nothing's being omitted, and then make clear they are clear on what your instructions are. At the end of that meeting, they can give you, and I can give you, a much more exact number about what my cost would be. As a general rule, anyone that's referred to me from Bill and Tara, I don't charge for that initial meeting because I don't know if I'm going to be able to help them. But I don't want to invent a number in the middle of a presentation which is not relevant to your situation.
Okay. All right. Under the caption during life, you mentioned HIPAA authorization. What were you referring to?
I'm sorry, somehow I didn't cover that in the slides. I must have skipped right over it. A very good question, and thank you for doing so. The HIPAA authorization is a listing of people that you put down and present to your medical providers, your doctors, hospitals, any place with an open medical file. And what you're telling them with that HIPAA authorization is these are the people who have access to my information. It's not giving them any authority. It's just under the federal HIPAA law, which refers to the Health Insurance Portability and Accountability Act. The doctors and medical providers are severely limited in who they're allowed to discuss it with. So they can't really speak with anyone except you and the Secretary of Health and Human Services unless you've set up one of these.
All right. Well, these are really good questions, and this is a lot of information. Thank you so much for everyone who's attended. We do have this presentation being recorded. So the recording will be available to you after the presentation. I'll send you a follow-up email, as well as by tomorrow, it should be up on our website under resources. But don't forget, this is a series, The Secrets of Successful Retirement, and we would love for you to join us next week, same time, 10 a.m. on Tuesday, for our next presentation that's going to be on Medicare and how to save on Medicare decisions and save on your prescription drugs. So if you are within that age range, have questions, whether you're on group health or you're turning 65, we'd love to have you join us. There's a lot of great information on that one. So with that, I'm going to thank Andy and Bill and all of you for attending, and we look forward to seeing you next week. We're also going to give away a free copy of our book, More Money for Retirement. So be sure to look out for that in the email as well. So have a great Tuesday, and we'll see you next week.